By May of 2019, there was a representation that there had been a legal process engaged in the state of Texas that involved, among other things, a alleged transcript from a disbarment proceeding. By the time I found it in July and August of 2019, I reread through the transcript because I was trying to confirm the specific lines in the transcript that I had seen in November and December of 2016, where a specific reference was made to an incident involving a cell phone that was used in the courtroom after the judge had given specific instruction about cell phones in the courtroom. The transcript had been altered. And in the alteration of the transcript, what was revealed was something that not only, I believe, was misrepresentation or tampering with an official court record, but that had national security implications, as well as implications in acts of slander and defamation. So I responded and filed with the Supreme Court of Texas and was engaged in, if nothing else, acts of slander and misrepresentation. I never filed an amici, and I never agreed to be used in acts of money laundering from and in connection with the state of Texas for anything having to do with any other process, including processes that may have engaged with or among or in connection with attorneys that were members of bar associations in other states besides Texas. I believe that part of what happened was in connection with the proposal I submitted to Bob Bennett. It's in three stages that I identified as courses. That was an effort at understanding particular aspects. It's actually two courses. Now, one could have seen them as academic courses or classes, but it also had to do with almost like a sitting. Like if you're in a restaurant, sometimes there's more than one course. You get certain things delivered to you, you partake of them, the table's cleared, then you deal with the second course, or sometimes more. Sometimes there's more than two courses. And it said specific direct reference to my former time when I had been in Houston. I did not have a conscious understanding at the time that there may have been some outstanding obligation, or it may have been connected to access that other people had to information about me or what had happened when I was in Houston in 2005 and 6. But in retrospect, I believe that's what happened. I believe that without telling me, there might have been some other effort to connect the dots, so to speak, in consideration of the fact that I had worked for a capital defense law firm in Houston when I first went to Houston in 2005. And despite whatever else might have been considered about my parting from them, one of the things I did do was maintain the facilities while everybody else left town during a hurricane that happened following Hurricane Katrina. And I told Bennett about this. And I think that somehow something connected to that had already been put into process and had already been either established or reestablished before I even offered this to him. And that was part of the unconscious cue that I picked up in the actual composition, the manner in which I proposed the actual proposal that I gave to him. He never discussed this. Nobody ever discussed that. But I'm pretty sure at this point in time that that's about expectations of that kind of discussion or that kind of candor weren't in the original deal they set up, right? This has happened a couple of times. Or I want to read it and then something makes me hesitate, like I don't want to read it. Because there's two things that are going on here. One is that somebody copyrighted this. So then there's this whole thing about, well, am I going to violate the copyright claim? And then you're going to begin some other undisclosed process where you attempt to lean on me and justify leaning on me because I violated a copyright that was never disclosed to me. Or somebody's doing another level. This is what happens. There's always more than two concurrent levels happening, and you expect me to just stick with the one that seems to be more appropriate for how you've assessed me as being able to have cognizability or demonstrated cognizability of the implications of what's going on, because that other level you've already assigned as being somebody else's range of value. And even if I have cognizance of it, you don't want to acknowledge that I'm the one that is actually engaged at that level because you've already assigned those assets to somebody else. And it's very, very important you cover that up. But on the other level is also an understanding that somebody is engaged in a process of a sort of remote robotics type scenario where they attempt to command and control individuals as actual vessels or vehicles and establish their command so that then they can justify having access to them as an asset that they can apply or employ and deploy elsewhere. You know, the whole submarine, the whole State Department process that apparently has been going on since the 1950s, where the United States just loans out submarines to other countries. Most of the countries get submarines, usually two. A couple get three. Some countries get destroyers, unless you're Germany. And then if you're Germany, well, the United States was really bad after the war. There was some port damage, and we owe some restitution to the Germans for that port damage. Until you identify the flag on your vessel, I don't know if you're a friendly or a hostile. And I'll shoot on sight everybody I fucking see for the next 24 hours. That includes him. You try to pull any more of this, he's just a sweet old Texas boy who's going to bring in some fucking pizza right while I'm talking about a Jewish woman, I'll shoot him too.